Welcome to MSL Presents an Educational Forum's Question of Law. This program is produced by the Massachusetts School of Law and is shown nationwide. America sits up and takes notice when the United States Supreme Court does something really bold, like ending racial segregation, creating a new constitutional right, or settling a presidential election. But now and then, the court also sets off a quiet revolution in America, something that makes a profound difference to our society, but not something that gets talked about routinely around the office, in the factory, or over the dinner table. Right now, the Supreme Court is in the early stages of launching one of those fundamental social changes. It involves the very controversial question of how to select a fair but effective punishment for those found guilty of committing crimes. Of course, most of us have an idea of what we think is proper punishment for criminals, and some of us might even get to express that when we serve on juries in the most serious criminal trials. But it is important to look beyond mere private opinions about punishment and examine the system that selects a specific penalty for a specific crime committed by a specific individual. That system is undergoing basic changes, and some of the most important changes are not widely noticed or understood. This program is the first of two on the quiet revolution that is now unfolding on crime and punishment. In these two programs, we will try to bring you up to date on what the Supreme Court has done in this branch of the law, what it means, and where this all might be heading. First, we will examine the changing role of the jury in punishment decisions, the increasing power the court is putting in the hands of those 12 good citizens in the jury box. And in our second program, we will look more deeply into the changing constitutional landscape of the death penalty. MSL Presents is pleased to be joined for these two programs by one of the country's leading experts on criminal sentencing, Professor Douglas Berman of Ohio State University's Moritz College of Law. He operates perhaps the best-informed internet site on the law governing sentencing and is one of the editors of an influential periodical, The Federal Sentencing Reporter. Welcome, Doug.
Thank you very much.
And once more, I have the pleasure of welcoming back Lyle Denniston, a veteran Supreme Court reporter who's a frequent commentator here and who has been watching up close the court's role in this quiet legal revolution. And I am Constance Rudnick, a professor of law at the Massachusetts School of Law. Professor Berman, why don't we start with a very broad question? This country's prisons are filling up, and no matter how they are expanded, how many more are built, the cost of maintaining the inmates and facilities is an enormous drain on the federal pocketbook. As a general matter, are we sending too many people for prison, and does that tell us anything about the sentencing system?
And like all good questions, I'd answer it like I do with my students. It depends. It really depends on what we think our focal point should be in our crime and justice system. A number of folks say, particularly members of this current administration, that we've reduced crime considerably by taking this tough-on-crime attitude and locking more and more people up. But a number of critics, I think, have some sound points when they say we're really filling our prisons up with nonviolent offenders, with drug offenses, with the kinds of offenders who really pose no significant threat to society and could be better treated in other ways. And you mentioned the costs are truly staggering. The amount of money that we're spending in jurisdictions on prison, on the criminal justice system, often far outpasses not just our higher education spending, but sometimes our entire educational spending. And there's a real reason to be sort of questioning whether that's a good use of our resources.
What's the present pulse of America with it when it comes to being tough on crime and tough sentences?
I think it's evolving, and I think it's very much subject to crime of the moment headlines and also the way in which politicians decide to frame this. And there's actually a very good example out of the last election cycle coming out of California. They had an initiative to amend their 3 strikes laws to make sure that it would only apply to violent offenders. And the early polling showed that Californians overwhelmingly favored that amendment to essentially go somewhat softer on crime by a 3-to-1 margin. But late in the election cycle, Governor Schwarzenegger decided to make a big campaign issue that this amendment would be dangerous, that it would let some criminals out of prison, and quickly the public pulse changed, and the amendment was actually defeated by a fairly close margin, even those against the amendment said that it was raising a lot of important issues about how tough three strikes law was in California. And so we're seeing a lot of volatility, I think, because a number of people realize we may have gotten too tough in some instances, but there certainly isn't a general feeling that there are too many prisoners who deserve to be walking the streets again.
And certainly the recent discovery of the bodies of two young girls who were killed by convicted child molesters who had been released from prison doesn't help those people on the side of arguing that we imprison too many people.
That's absolutely right, and I think sex offender sentencing particularly is an area that's getting increased attention. The severity of the sentences there are already pretty great, but every time we hear of these cases where someone's been released and committed another crime, it creates an anecdote that can sort of rally the let's get tougher attitudes, and always data will get eclipsed in those conversations. And so what's interesting in the sex offender arena is there's actually data that suggests a lower recidivism rate for sex offenders than for most other criminals. But again, that gets lost when we see that one case where the recidivist has done something terrible, and we all understandably react emotionally. Why did that person get out?
It's like the public's perception that everybody gets off on a loophole.
Right, yeah. Okay. The anecdote always eclipses the broader story.
Right. In the opening, it talked about have an increased role that juries are playing, and that's sort of antithetical to what everybody thinks, and that is that judges are in control of sentencing. So how are juries have input?
Well, there's a long story here, and it's really an interesting historical story. Judges certainly have always been at the center of the sentencing universe, but that universe is often defined by how legislatures give judges that authority. And you go back historically, for quite some time in our early history, judges had very little power at sentencing. It was more of a ministerial task. The legislature would say, X number of years for a certain crime. A lot of cases were actually automatic death penalty. The judge didn't really have much opportunity to mitigate that or change that at all. Then through sort of the 18 and 1900s, the shift in the philosophy of punishment to go towards more rehabilitation, to try to figure out how to make sentences that would allow offenders to be rehabilitated in prison and other mechanisms, led to legislatures giving judges a lot more authority, a lot more power to try to craft individual sentences. A number of states, Massachusetts in particular, had a range of laws that gave judges for almost every crime the authority to sentence between 1 day and life imprisonment. No matter what the crime was, judges would have this broad authority. And that's how we think of it, that's how we see it on TV. That still, in some sense, accurately portrays what's going on. But over the last couple decades, legislatures have gotten more involved in trying to structure judges' discretion, have created legal rules that judges have to follow in deciding what sentence they can impose. They still have pockets of discretion, but much more of a sort of regimented set of decisions that judges must make at sentencing. And this new revolution, including juries, has really been about whether under those new laws, judges have all the authority to find the facts that are necessary the legislatures have called for, or in fact, now that the legislatures have changed the rules, whether juries have to play a more fundamental role in deciding when a judge has discretion to impose certain kinds of sentences.
So it's not really that the jury either has the authority to recommend a sentence or to actually impose a sentence. It's more with respect to the jury finding facts upon which the sentence gets based.
That's certainly where it's been going, although the sort of simplest story is that it's never that simple. In fact, in a few states, there still is a form of jury sentencing. And so there are a few states, Virginia particularly comes to mind, where it's fairly regular, Texas as well, where juries actually do recommend sentences even in non-death penalty cases. And as we'll talk about in the second hour, in all death penalty jurisdictions, juries have a very fundamental role in deciding who's going to live or die at sentencing. And so, again, the jury's role sort of is nuanced in different settings, but absolutely this new sort of line of constitutional cases have been focused not on the jury recommending a sentence, but on the jury finding the facts that the law has made essential to the sentence.
Okay. Lyle, you're only here when we talk about the Supreme Court. You're here most of the time when so how is the Supreme Court involved in this?
Well, the Supreme Court obviously is interpreting the constitutional law as an ultimate arbiter of questions that bear upon guilt and innocence, bear upon sentencing. And so the Supreme Court in this area, most recently in the last 4 years, really, has started the revolution that you mentioned at the opening. And what they are doing is reestablishing, or if you will, newly establishing, a central role for the jury in establishing facts. And they've done that in a series of decisions, which for lawyers are called the Apprendi line of cases, where the court is saying that the jury's role is really central to the whole sentencing process. And you cannot have the judge coming in and finding facts independent of what the jury has found and then basing a sentencing decision upon that. And this is, of course, a very controversial, at least within the legal community, very controversial development. But it seems clear that the present trend is going to continue at least until there's some changes in the membership.
What part of the Constitution is the court using as its basis when it makes a decision that the jury has to have an involvement in the factual basis?
Well, the Sixth Amendment guarantees a right to a jury trial. And of course, like most of the Bill of Rights, the guarantee of a jury trial applies to the states now because of the revolution that, another quiet revolution that occurred in the 1950s. The
incorporation doctrine.
Yes. And so that with most of the criminal justice system still functioning at the state level, numerically or statistically, the court has been interpreting the role of the jury under the Sixth Amendment and the role of the judge in relationship to the jury.
Okay. The cases that you mentioned, the Apprendi line that comes from the Supreme Court, they've all been 5-4 decisions. Traditional split, same way, conservatives on one side, liberals on another, and Kennedy and O'Connor switching back and forth?
No, this is really an aberration in that trend. It's always, as you said, 5-4, and in every one of these cases, the breakdown is the same, with one exception, the most recent one. The majority is always made up of the two most conservative members of the court, Justices Scalia and Thomas, and the three probably most liberal, or at least the most moderate justices, Justice John Paul Stevens, Justice Ruth Bader Ginsburg, and Justice David Souter. And then in dissent are both O'Connor and Kennedy, along with the Chief Justice, and another moderate, Steve Breyer. So it's a real mix-up from what we normally expect to be the predictable trend in a close division of the justices.
How do we account for the strange bedfellows?
Well, I think you have to look at each justice's own jurisprudential history. Scalia and Thomas probably are looking at these issues through what the original understanding of the Constitution was, the role of the jury versus the role of the judge. The moderate to liberals are probably looking at it in terms of some kind of social value perspective that they often do, and they are saying that the need for honoring the right to a jury trial is more evident now, and they're not really opposed. Any of these people are not really opposed to what's called sentencing reform, but they're very careful about how sentencing reform fits into their perspective about what the Sixth Amendment really requires.
In fact, I would imagine that Scalia's position in the Apprendi line of cases is consistent with other of his criminal defense decisions,
Surely,
in which he relies heavily on the history of the Constitution and the Bill of Rights, and talks about what the Confrontation Clause, for example, means and what it meant in time in England and where we came from, and so that's one of the things that he considers to be very important, and that is the historical perspective.
He and Thomas, and when they interpret the Constitution, they interpret it in terms of the way it was written originally in 1787 and in 1791 when the Bill of Rights were added. Thomas, by the way, resists the idea, though it's well established, that these rights should apply at the state level too,
right.
But Scalia hasn't gone that far. But they also look at the common law as it existed at the time of the founding. So they're drawing on history. The others in the majority are drawing on, I think, probably more ideological perceptions about what the jury trial right ought to be at this time.
Okay. Professor Berman, Lyle mentioned that most of the sentencing in this country goes on at the state level. Do the statistics bear that up?
Oh, absolutely. In fact, the federal system gets a lot of attention, but it only represents about 5% of the criminal cases nationwide, and so 95% of the sentences go on at the state level. The federal system gets more attention in part because the higher profile cases will usually be there, you know, the corporate frauds, the accounting scandals, those sorts of cases, the Martha Stewarts of the world, absolutely. They're the ones. Exactly. And so, you know, they typically are cases that will have national importance. And so it's not surprising that the federal system often gets sort of, you might even say undue attention, but it's absolutely right to recognize that what goes on in the states is not only as important, but in many respects a lot more important to sort of our day-to-day existence and our concerns about crime. Certainly the street crimes, those are disproportionately covered in the states, and it's a state concern.
Because in fact, the federal criminal law is limited. It has to have some basis in the United States Constitution, and it used to be that it was the Commerce Clause. So there has to be some crossing state lines type of thing in order to
and one of the really interesting things going on is historically the federal criminal system was even smaller than it's been of late, and over the last couple decades there's been a tendency to turn what seem like local crimes into federal crimes, and so there's another set of debates that are ongoing right now, both in front of the Supreme Court and just in the public policy discussion about whether the federal government should be turning more of these crimes into federal crimes, or in fact we should trust the states to be able to take care of this. And I think that also, you know, is percolating within the court as well. It's not just a question of what the sentences will be and who will hand it out, judge versus jury, but also state versus federal, and the structure of the criminal justice system throughout our country.
Okay. The sentencing reform that Lyle talked about, the Supreme Court starting, is that applicable to both state and federal prosecutions?
Absolutely, and that's something that's again, the state story is a little bit more nuanced because different states have approached it in different sorts of ways. And the broad story is very common, that all the discretion that we talked about, this authority of judges to come up with a sentence between a day and a lifetime, throughout the 60s and 70s there was a real concern that there was disparity, that judges were not always making choices, and often a particular concern that discrimination might influence that upper middle class white offenders might get the benefits of the doubt, whereas minority offenders wouldn't be as favorably treated when the judge had discretion to decide whether they thought a person would recidivate or things of that nature. And so a number of states and the federal system as well started to structure sentencing decisions. And again, it's quite diverse in the states. Massachusetts, I know, in fact, has worked on sentencing reform to have some of these new laws, but they haven't quite been enacted.
Yeah, it's been an idea in Massachusetts that's been percolating for a long time, and there's a commission actually that's pending now considering the question of whether to have what is known as sentencing guidelines.
Right, exactly.
So why don't you explain just what a guideline is?
Sure, and it relates to this judge-jury story so very well, because guidelines were enacted to give judges a set of sort of guideposts, a series of decisions that a judge would need to make to take a broad sentencing range. And so I can use the federal system sort of most easily. An armed bank robbery prosecuted in the federal system produces a statutory sentencing range of 0 to 25 years, which means the statute which prohibits armed bank robbery says the sentence could range anywhere from 0 to 25 years. Sentencing guidelines were enacted in the federal system to give a judge a variety of factors to look at to decide where to go within that very broad range. So to look at, well, gosh, how much money was taken? And was there a getaway car that was stolen, or were people hurt?
Was a gun used?
Exactly.
Well, armed robbery would
but you know,
be a gun,
was
right.
the gun one of the factors is, was the gun discharged or was it just brandished? And so the guidelines are intended to, as the name suggests, guide the judge into deciding what sort of sentence within those broad ranges come through. And the way it had operated before this modern line of Supreme Court precedent was the judge would make all those determinations, and the judge would go through guideline calculations, and it sort of looked like a formula in many ways, and come up with, instead of a range of 0 to 25 years, a much more confined range, 60 to 70 months or something along those lines. And the controversy has been, well, how about those determinations? Shouldn't that be made by a jury rather than by a judge? If it's important and the sentence depends on whether or not the defendant fired the gun or just had the gun, shouldn't that be something that a jury weighs in on rather than have the judge make those determinations? And so the debate has been in the states that have these guideline systems, do judges have the authority to find all those facts that the law has now made essential to the punishment, or is that now a jury determination? And again, the story gets very, very complicated because then there are also facts that relate to the offender. The offender's criminal history gets calculated in this as well, and so the court has really been struggling to figure out which particular determinations have to be made by a jury rather than a judge.
Okay. Well, we have to take a break right now for an ad or a public service announcement, and we will be right back, and we hope that when we come back, you will be with us.
They won't leave you for someone younger. They won't notice you've gained weight. They won't fire you. They won't talk about you behind your back. All they'll ever do is love you. Find the love of your life. Visit Petfinder at aspca.org.
Hey, this phone's taken.
Son, will this help you?
Maybe the last thing you would do for somebody should be the first.
Thanks. Hey, I appreciate it.
A message from the Credit Union Foundation and your hometown credit union.
Welcome back to MSL Presents, the Educational Forum and a Question of Law. And we are talking about the role of juries in the sentencing process in the United States. Lyle, let's try and narrow down the legal effect of the Supreme Court decisions. Do the Apprendi line of cases apply only in situations where you're talking about what we call enhancement factors, such as was a gun used in the commission of a crime? 3 strikes and you're out. Is the person a leader in a major figure in the criminal activity? Or does it apply to facts which would go to the element of the offense as well?
In a theoretical sense, at least, and Doug can tell you about the real world sense, but in theoretical sense, what the court has been doing is trying to sort out, as a constitutional matter, the differences between those facts which are a part of the crime that's committed. For example, did you kill someone? That's a fact. And it's when the court has always said, when it's an element of the crime, when it's necessary to find this in order to convict, that's a role for the jury. But then previously the court had said, if it's just a sentencing factor, in other words, if it simply affects the particular point along the spectrum of where the judge pinpoints the actual number of years that a person gets or the amount of the fine, that sentencing factor can be decided by the judge and would be decided by the judge. Well, the court has sort of abandoned that kind of theoretical model and has said you can call it a sentencing factor, but if it contributes to the actual determination of guilt or innocence, it is a fact that it should be decided by the jury, and therefore the predicate for the sentence must be decided by the jury. And that's the theoretical model. So we're moving away from this kind of rigid dichotomy between elements of the crime that are usually statutory and sentencing factors, and the two are kind of getting mixed up, with the jury gaining authority in the process.
Okay. Professor Berman, can we use an example? Let's use your armed robbery situation.
Sure.
Okay. Now, what sentencing factors would the jury have to find in order to have a constitutional sentence? And what I'm thinking of is, one of the things that in the federal guidelines is criminal history. I mean, would the jury have to find that the defendant has 2 prior criminal convictions that fall under the criminal history section?
What's funny and why this gets so complicated, or at least keeps me in a job, is there are all these exceptions to the Apprendi line. And so there was an early case, goes by the name of Almendarez-Torres, which marked out what we call a prior conviction exception. And the court, and there's another 5-4 decision, and the history here is complicated, but the simple idea is that the court has said there is one exception to when the jury has to find this stuff, and that is when it is the fact of a prior conviction. And the theory behind that would seem to be, well, a jury has previously decided that, or that's been established in a way. And also, Justice Breyer, in that opinion, said it would also be prejudicial to a defendant being tried for this crime to have evidence about his prior crimes brought into the trial. And so there is this exception. But interestingly, just last month, it was actually earlier this month, Justice Thomas said we should get rid of that exception, that we should overrule that exception, that it doesn't make any sense. This Apprendi line of cases, which is about giving juries more power, ought to also apply to criminal history. Interestingly, he was one of the deciding votes that established that exception, but he's changed his mind over the last few years. And so there's a lot of uncertainty right now whether that exception will stay in place. But you put your finger on another kind of factor that historically has been seen as very much something that a judge thinks about, not something that's for a jury, but that the court is struggling to figure out who should make the decisions now.
Okay, so let's use your armed robber, and we'll assume it's a federally insured institution,
Good.
which would make it a federal crime.
Right.
So we'll use the federal sentencing guidelines because those are the ones I'm most familiar with. Now, what would be factors that a jury would have to find that are relevant under the sentencing guidelines?
I'll give you how the sentencing guidelines are structured, and the story gets even more complicated after that. The 2 basic ones, the ones that are good to simple to look at, that are easy, would be the way the gun was used, right? And we all have this sort of instinct, gosh, if the person had the gun in his pocket and never came out but just said, I had a gun, that's a little bit different crime than if he runs in shooting and screaming and, firing bullets over people's heads.
Even though both would technically be armed
bank robbery. That's correct.
Okay.
But we would think, and I think it's right, that we'd expect a judge or a sentence to vary a little bit if the person was causing a much greater risk of harm with the amount of money, the amount of violence that they were at least threatening by shooting the gun around, or maybe if he has 5 guns versus 1 gun, those sorts of things. Another one that is very much a part of these economic crimes is the amount of money involved. If he goes in and he heists $100, it feels like a different crime than if he goes in and he heists $100,000. And so the federal sentencing guidelines had built that into the instructions to the judge. Judge, find out how much money was lost. Judge, determine how the gun was used. Judge, also determine whether anybody was hurt. Again, you can imagine running out of the bank, pushes an old elderly person aside. That person falls, breaks their hip. Seems like a more serious crime now, even though they may not be charged with a separate crime for that. Again, the guidelines instructed the judge to make all these findings. And what the Apprendi line of cases now says is, sorry, those are the kinds of findings in which we want a jury determination. We don't think it's appropriate because each of those findings will lead to a longer sentence under the federal system.
Even if the sentence is ultimately within the
0 to
statutory
25,
guidelines.
That's right.
Okay.
That's what was so controversial, although where this gets complicated is when the Supreme Court directly confronted this issue in the federal system, and this is the most recent case called Booker. They ultimately decided, there's a problem. There's a problem that the judge was allowed to make these findings. But the way we're going to deal with that problem is not to require juries to make that finding anymore. We're going to say the guidelines are no longer mandatory. That Justice Breyer put together a coalition of justices, and it was Justice Ruth Bader Ginsburg who switched teams in a sense to have the remedy for the problem in the federal system be that the guidelines are no longer binding on judges. And the thought is that eliminates the problem because these facts are no longer essential to the punishment. Now they're just considerations, right? And so That's the story in the federal system. What's been interesting to watch is in the states, they've typically not taken that approach. Their attitude has been, oh, we've got to apply this new line of precedent. We now need juries to make these sorts of determinations under our state laws. And so, again, we're getting an enormous range of reactions to this new line of precedents going on, playing out at the ground.
Okay, I want to talk about the reaction, but from a practical standpoint, let's say you're in a state that doesn't have the option of a mandatory guideline versus an advisory guideline. How does the judge know what the jury has found with respect to the relevant facts?
And what's happened after the Blakely case, which really made it clear that this needed to be done in the state guideline systems, judges have been giving special questions to the jury, and so the jury has been asked to weigh in on these factors that the law provides. Sometimes judges are able to, in a sense, infer from the jury verdict that there were literally 9 times out of 10, a conviction is secured through a plea bargain. And so the real question is, what happens in those cases? And since this Blakely decision came down, which made it very clear that Apprendi applied to the state guideline systems, a number of prosecutors have tried to put into the plea agreements these factors to get the defendant to admit to these facts as part of pleading. So the judge can say, and the Apprendi decision highlighted this, it's either a jury finding or the defendant's admission.
Admits to it.
And so that's the way in which a lot of this has been playing out on the ground, is judges don't always have to really rely on what the jury found. More often than not, they're looking at a plea agreement, and then the question is, did the defendant plead guilty to stealing $100,000 rather than 100, or plead guilty to discharging the gun rather than just keeping it in his pocket?
Yeah, and there's another method, Toonie, where prosecutors actually put the facts in the charging document. For example, the indictment. In the past, they would charge with a crime that might just be boilerplate language. Then they would bring out the facts during the trial, or they would be facts that were left for the judge after the verdict of guilt came in. But now what more prosecutors are required to do in order to make sure that we know that the jury found them is to allege the use of the gun and how it was used in the original indictment, which, by the way, in some practical sense, limits the prosecutor's authority to try the case, because you're going to have to try only on the facts that you put in there, not stuff that you can develop in the course of examination or cross-examination. So prosecutors are not terribly happy about that development.
Lyle, was the Apprendi case and the cases that follow, was that a surprise from the Supreme Court, or would an astute observer of this court's jurisprudence have been able to predict this quiet revolution?
No, I think they were a surprise, because there's been a lot of discussion in the last decade in the court over this question of whether it's an element of the offense or whether or not it's a sentencing factor. And the court was getting increasingly uncomfortable with that. But when the original case, the Apprendi versus New Jersey, came out, which was an enhancement case involving a hate crime, I think the biggest surprise was the division within the court. I mean, this crossover voting that we were talking about. So the result itself seemed to some degree to be a natural evolution out of the discussion of how we're going to rearrange this sentencing regime or universe, but the actual voting patterns were an astonishing development.
Doug, you've been following the sentencing cases that come out of the Supreme Court. Were you surprised at Apprendi and then Blakely and Booker, or did you expect that the Supreme Court was going to undo 20 years of sentencing in the federal system?
They were certainly surprising, and the backstory here is to some extent that for 15 years or so, the quiet revolution was in legislatures and in sentencing commissions developing these new sentencing structures, and a number of defendants would challenge how those were being applied in court. And typically they'd more or less get the back of the hand from the Supreme Court. The court had seemed to have little belief that there was any problem with the way legislatures were creating these new sentencing laws and the way they were being applied. And so there were a series of decisions in the early 90s where the court was almost sort of dismissive. Only really Justice Stevens was complaining that these new sentencing laws were being applied in a way that raised some concerns. And then just before Apprendi came down, this Amenderes-Torres case I mentioned, and there was another case the following term called Jones, where the coalition started to form, and you got a little bit of the sort of tea leaves that you could start reading, and so there was a degree to which we had a little bit of a warning before Apprendi came along. But what really is interesting is to sort of speculate what turned the tide? What was it that had for some time, particularly for I think Justice Scalia and Thomas, had let them feel comfortable with allowing legislatures to create these new sentencing structures? What was it that sort of led them to believe that we had really put the place of the jury and these traditional criminal procedural protections, we put them aside too much in these new laws and the way in which they operated? And we can all sort of mind read. I look forward to reading their papers and someday to sort of figure that out, because it is surprising the way in which these justices formed to create this new coalition.
What about cases that didn't deal exactly with a division between the juries and the judge, but cases like the Watts case, in which the Supreme Court said, I think it's perfectly all right to take into account uncharged conduct and acquitted conduct, and I'm sure that our audience probably doesn't understand, but correct me if I'm wrong, under the federal sentencing guidelines, if you are acquitted of a charge or a charge is not brought, but that charge has relevance to the charge in which you have been convicted, the judge could take that into account. And the Supreme Court said that's perfectly constitutional. Now, how do you square that case with the Blakely and other cases?
That's exactly the tough question, because it actually is 1997. It wasn't that long ago that Watts came along, and you described it exactly right. And there was a drug crime that was involved that the government also alleged that there was a gun also involved, and the government charged as two separate crimes, the drug crime and then a separate crime for having a gun with a drug crime. The jury acquitted on that gun charge, but the judge at sentencing, reading the guidelines, said, well, I have no choice. I think the gun was there. I'm convinced, to use the legal parlance, by a preponderance.
Right, as opposed to by a reasonable doubt.
The jury may not have found beyond a reasonable doubt,
Right.
but I really think the gun was there, and I read these guidelines, and they mandate that I consider that and that I increase the sentence as a result of that. The defendant appealed, and the Supreme Court said in an 8-1 or 7-2, depending on how you count decision, that's just fine. We have no problem with that. That's part of the considerations.
Because those are the kind of the sentencing factors that judges have taken into account,
Exactly,
unreviewed, for as long as we've had sentencing.
Back in those days where we had complete discretion, this was very common, that it was just sort of classic. It goes back to a case called Williams back in the 40s, where the judge had a pre-sentence report with all sorts of uncharged crimes in there, and the court said that was okay. And so that was really what I sort of seen back in the late 90s. Oh, this is it. There's just really no special protections at sentencing. And then it was just a year or two later that this new Apprendi line of cases developed. And I'm inclined to speculate that it was after Watts came down and after the court had a sort of chance to reflect on what
they had done,
and that it strikes me that Watts is particularly undermining of the jury's role, because it's not just a judge considering factors that didn't come before the jury. That was a case where the jury considered it, rejected it, and yet these guidelines still instructed the judge to follow it. And again, I found it remarkable that case came down the way it did. Even more remarkable that only a few years later the court would reverse course so dramatically.
Yeah.
Did the court overrule Watts in any of the cases?
No, they haven't
so,
yet.
So how do we account for you watch the court closely? How do we account for what both in practicality and in theory appears to be a 180 turn on the issue of the judge's unchecked authority in federal sentencing?
You recognize there's been a 180 turn, and then you apply the most recent decision. I mean, even though the court hasn't overturned Williams or Watts explicitly, I think you could understand that they're probably no longer controlling cases. But I think it is pretty clear that this court took a little time before it was moved to do this. And I think a lot of people assume the Supreme Court of the United States suddenly gets a notion in its head and then strikes, just like a bolt of lightning. But it takes a lot of time for these things to mature. And when you have a court like this one, which has been so long together, I mean, almost 11 years now, issues don't get brought up quite as quickly among the justices as maybe we need to turn our attention to that, because they're in the habit of working together, and each of them has a kind of a line of substantive law that they're interested in, and this one just wasn't figuring prominently within the conversation. And then, as Doug has pointed out, somebody started getting a little fretful about it. Hey, wait a minute, maybe there is something quiet going on here that is not quite right. And I think that's what turned it around. Somebody started agitating within the court. Somebody said, let's grant a case that gives us a chance to rethink this, and we will rethink it, and they did.
Okay, we're going to have to take another break. But when we come back, I want to talk about how come it took 20 years for the court to awaken, because there had been all kinds of stirrings and ramblings from certainly the criminal defense bar about how horrific the sentencing guidelines have been. So we'll be back again, and when we are back, we'll expect to see you.
How far would you go to help someone? Would you go to the end of your driveway? Would you cross a street? Would you cross an ocean? To a place 6,000 miles from home? And how long would you go? Would you go for a week? A month? A year? Would you go for 2 years? Would you go if you could use your knowledge to teach someone, and in the process, maybe learn something yourself? Life is calling. How far will you go? Peace Corps.
Integrity first. Service before self. Excellence in all we do. These are not just words. These are our core values. Values by which each and every member of the Air Force Reserve lives. So whether we are deploying humanitarian aid or providing natural disaster relief, or defending freedom wherever it's threatened, the men and women of the Air Force Reserve are there, protecting our values and serving our country. Air Force Reserve, above and beyond.
Welcome back again to MSL's Educational Forum, and we're here with our guests talking about the increased role of juries in sentencing for criminal offenses. When we broke, Lyle, I had mentioned that the federal sentencing guidelines went into effect on November 1st, 1987. So it's, let me see, this is 2005, well, let's say 2004. So it took 17 years, basically, for the Supreme Court to recognize that there were problems with these guidelines, even though there had been members of the defense bar who have been screaming and hollering from November 1st, 1987, that these were grossly unfair, they were inappropriate, and in fact, if I'm not mistaken, there were a number of federal judges who resigned over the fact that they had to follow these guidelines. So how come it took so long?
Well, I think it's a question of whether it's on the radar screen among those 9. And one factor here that we haven't mentioned, but it often works into much of what the court does, is that this court is very much inclined to try to reduce its caseload over a period of time. I mean, and I think we've mentioned on this program a couple of times, the court right now is deciding half as many cases as it did in the early 1980s. So the question is, which squeaky wheel do you pay attention to when there are as many squeaky wheels as there are, and you're willing to decide how to put oil on which one? And I think that's probably the main factor. It isn't, I don't think you can say that the court was indifferent to the real world effect of things like Watts, for example, or this, the gross disparities that resulted. I think it was simply that it just didn't occur to them to be a high priority item. I don't know whether Doug sees it that way as well.
I basically agree, and I'd actually say, and this maybe gets us to our next hour, but the death penalty squeaky wheel really has had the court's attention for the last 3 decades in a way that has led it, I think, in a variety of ways to be less attentive to the more sort of common but less high-profile sentencing cases. And so, given all the time and energy they've spent regulating the capital sentencing process, they sort of had a corresponding sort of hands-off attitude with respect to non-death penalty sentencing. And in fact, another case early on from the 1980s, a case called McMillan, the Supreme Court, not surprisingly speaking through Justice Rehnquist, really articulated a deferential approach, that legislatures are in charge of defining crimes and punishments. Unless it gets extreme, it's just not our job to muck up the process. And he has a line in the opinion for the court there that we shouldn't be constitutionalizing burdens of proof, that it's not the court's role to play sort of an active sort of regulatory body on the way the sentencing process is playing out. That's for the legislature to do. Of course, we'll check them if they get out of hand, but other than that, we're not going to be that actively involved. And I really do think it's itself a reflection of how involved they've been in the death penalty, that they've spent so much time, so much of their quite limited caseload has been occupied with all sorts of death penalty issues, and it's a squeaky wheel that understandably seems appropriate because we're talking life and death there, and that one of the reasons the court has had been so deferential to the legislative approach in the other cases was that they maybe were almost exhausted from the death penalty cases. And I think to some extent that ultimately the 5 justices of the court said we can't do that anymore, that this is just too many cases are involved, too much liberty is at stake, the length of the sentences have gotten so long that this is no longer small time stuff. This is a big ticket, not quite as the death penalty, but close. And so that's, I think, another factor that explains sort of the evolution we've seen.
Okay. Lyle, before I do want to ask Professor Berman about what the practical fallout has been from these cases, but before that, some of the fact patterns that were raised in the cases that the Supreme Court had the opportunity and did decide are rather extreme. Can you give us an example of the facts of one of the cases which might have really cried out for the Supreme Court to intervene?
I think this illustrates why the guideline system ultimately looked so horrendous to the court. I mean, this was a case involving a fellow named Dukan Fan, an oddly spelled name, but a fairly young man in Somerville, Massachusetts, who was charged with powder cocaine offenses, and he was charged with dealing in powdered cocaine, and the jury found that he was guilty of dealing in at least 500 grams of cocaine. Well, under the guidelines, based upon that jury finding, he was likely to get up to 6 years in federal prison. Well, the prosecutor said, wait a minute, this guy wasn't only dealing in powdered cocaine, he was also dealing in crack. But they brought this up at the sentencing, and they said, look, under the guidelines... He wasn't
charged with that.
He wasn't charged with this. The jury had never had this presented to them. So the prosecutor said, well, now, wait a minute, under the guidelines, Judge, you can take this into effect. And if you do, Mr. Fan can get 19 years and 7 months as a maximum instead of 6 years. Well, as it turns out, this involved a judge, Judge Hornby up in Maine, who said, wait a minute. He was following the Apprendi line of cases, and he says, sooner or later, Apprendi is going to reach the guidelines issue. I am only going to impose a 6-year sentence on Dukan Fan because that's all the jury found. And the court recited that history in the case, and now Mr. Fan, even though he benefited from the Sixth Amendment interpretation, he is entitled to ask for even less. Whether he will get it, I don't know, but he could be a beneficiary of this in another way.
Okay, that brings us to the next point, and that is the Supreme Court has held that the jury doesn't need to find all the facts. You can just make the sentencing guidelines and non-mandatory but advisory. So tell me, is everybody who's sitting in a federal penitentiary, having been sentenced under the guidelines in the last 17 years, now running back to court and screaming?
Yes, simple answer to that. I mean, I'm not sure every single one is, but absolutely there are literally hundreds of thousands of prisoners, state and federal, who were sentenced under a system that now the Supreme Court has said is constitutionally problematic. This gets a different layer of complications around what's called retroactivity doctrine, and that's a set of rules the Supreme Court has announced that limit how far back this goes. And the idea is, look, the system has to value finality even if there was a problem with what happened 10 years ago and we've changed course, there's a limit to how many cases we're going to reopen. And so it seems, and a number of the lower courts have held this already, that it's unlikely that persons who had their convictions finalized, meaning they had done all their appeals, they're going to get any relief here, although that, again, is still subject to litigation all the way up to the Supreme Court. But the Supreme Court announced in this Booker decision, which turned the federal guidelines into this advisory system, that it had to apply to every case currently in the works. And because the federal criminal justice system is so large, that's still tens of thousands of cases that have to sort of sort through what an advisory guideline system means. And it's been sort of fascinating to watch different courts interpret that in different ways. One of the things that is, in a sense, ironic is it seems to undercut the very principles we've been talking about here, that by making the guidelines advisory, you, in a sense, even take juries more out of the loop and make judges' roles even more important because they can even determine to go less or more than what the jury found under this advisory guideline system. And so a number of judges have struggled reading the line of precedent saying, I think this is about jury rights and I think it's about defendants having greater rights. I'm uncomfortable applying this advisory system the way the court has suggested because, again, we have these sort of shifting majorities that have defined this new universe. And so the simple story is it's very complicated to figure out how this new rule is going to apply both to past convictions, to current cases, and then in the future, again, it's going to depend on how prosecutors and defense attorneys negotiate about the issues around sentencing. Because, again, at the end of the day, it's all about pleas.
Now, I would imagine there's going to be a little bit more leverage on the part of the defense lawyers with respect to the plea negotiations, because historically, there really wasn't very much, because you knew if you pled to less than all of the charges, or if you worked out a deal that in which the prosecutor would agree to indict only on certain charges, you knew that all this stuff was going to come up in sentencing anyway. So there was really very little incentive to enter into a plea. You might as well roll the dice and go to trial. So have you been following the statistics, or can you see any trend? Are there reductions in sentencing happening all over the United States, or are the judges saying, you know, even though it's only advisory, I really like this, so I'm going to add my 1 point here and my 2 points there?
It's more of that. I mean, that we're seeing judges who have been sentencing under this system for the last 2 decades comfortable with it. And so I would still say in the run-of-the-mill case, we're finding the guidelines are being followed, even though judges no longer have to do that. But what we are seeing is, in the outlier cases, much greater variation. And that's in some sense what a number of folks who've always supported guidelines say is the problem. The problem is we're going to get some lenient judges who in a particular case is going to see sympathy and go below the guidelines. And so one good example recently, Governor Rowland in Connecticut was sentenced for his misdeeds in office, and he got a sentence below the guidelines. And the thought was the judge there was one who historically has been sympathetic to defendants. Gee, that's a problem. He's gone and given a more lenient sentence, whereas another person convicted of a fraud case out of New Jersey actually got a more severe sentence than even the prosecutor was recommending, because the judge in that setting decided to use his new discretion to be a little bit harsher, to speak out on public corruption in the context of that case. And so what we're really seeing is judges slowly but surely sort of feeling through which cases they want to use and exercise their discretion more regularly, and it's going to be sort of fascinating to watch over time where the guidelines are relied upon less and less as judges feel more and more comfortable going on their own path.
But historically, that's what they did, right? I mean, before they had guidelines, that's what the judge had almost total discretion in what they wanted to take into account. And some of the other sentencing guideline cases which said that you're only allowed to take into account factors which weren't taken into account by the guidelines, and which we know that the Sentencing Commission has not considered. Right. Now, what happens to that decision? Is that decision now out the window? And if someone wants to take...
It's still being litigated, and a number of these cases, judges have started to look at factors. The Sentencing Commission, which is the administrative body that writes the basic guidelines, they say, we don't think you ought to consider lack of guidance as a youth, or drug dependency, or age, or some other sorts of factors. A number of judges have said, well, but in the context of this case, I think that's a relevant consideration. Right. And you're absolutely right that this gets back to what judges like to say is we get back to being judges. And so a number of judges, most lower court judges, have really celebrated the decision and has been proud and pleased that they have an opportunity to consider more than what's in this very large manual that tells them what to do. But at the same time, a number of folks looking at the system nationwide continue to question, yeah, but does that mean that we're going to have persons with different outcomes, not based on what they did, but just based on the luck of the draw of what judge they get and whether they have a more lenient or a more tough judge that they're in front of.
And by the way, one of the things we should point out is that these judges who are on the firing line aren't likely to get any new guidance from the Supreme Court on how they should be doing this, because the Supreme Court, since the Booker decision, has sent back at least, 600
Yeah,
cases.
I think that's right.
It's approaching 700 cases that have been filed up there that were dependent upon this decision or have been filed since that. And the court has, in every case so far, has simply sent it back and said, apply our new decision. And so far as,
reversed and remanded in light of Booker, and that's the end?
And so far as it appears now, and I don't see any case immediately on the horizon or on the near term, where the court is likely to say, okay, you ladies and gentlemen on the bench down below, you need a little more help with this, so we're going to take this case or that issue. I don't see it. There's one or two cases already pending asking them to do that, but some of the cases that they've sent back raised issues that were sequel kinds of issues, even though they'd been filed before Booker and Fanfan, and the court isn't interested in those either. So the court, I think, wants to take a breather in this and see. I think, in fact, the Judicial Conference of the United States, which is the policy-making arm of the federal courts, recently adopted a statement urging Congress not to do anything, to give the judges a chance pragmatically to try to work with this
That was
system.
was my next question, and that was, is there going to be a legislative revolution to try and get around these cases, or what do you see happening?
It's certainly been proposed, and there's sort of been talk of how could Congress respond to this and should Congress respond, but the reality is the legal landscape is still so uncertain, and the way this is going to play out practically is still being determined, case by case, really week by week, month by month, that the consensus right now seems to be let's see how it goes. Let's watch the system in operation. Maybe this can work. Maybe advisory guidelines have enough force to keep most of the judges in check, but that the only times there'll be outliers are when there should be an outlier. And so I think Congress is inclined to hold its hand, but as we talked about at the beginning, one high-profile case may be all it takes to change that equation.
Okay, we need to wrap this up. Thank you so much for joining us.
Thank you.
Thank you for joining us, and we hope that you will be back with us when we return again on our next show on the death penalty on the Educational Forum Presents A Question of Law.
This is Alan. He has cancer. This is Sarah. They've been together 46 years.
Way to go, sweetheart. Now go get it.
This is the number they called when he was diagnosed, so they could get answers to their questions,
Kiss that ball.
so they could get through this together. This is the American Cancer Society. This is who to call for help.
I love you.
Every year, almost 14,000 women in our country die from ovarian cancer.
It can strike a woman of any age. My wife was only 36.
Unfortunately, symptoms are often subtle and hard to identify. but if detected early, ovarian cancer is usually treatable.
Talk to your wife about ovarian cancer, because if you think it's just a women's issue, you're wrong.
As husbands, we have all felt its pain.
Chronic pain is one of America's most urgent and ignored health issues. Each year we spend millions of dollars on medical research for painful diseases and conditions. But while we wait for cures, people are still suffering. Quietly, secretly, terribly. It's time for relief. That's why Congress has declared this the Decade of Pain Control and Research. To learn more, visit decadeofpain.org.